Hello, and welcome to another edition of Coffee Talk with attorney Brian D. Lerner. In this particular episode, I'd like to talk about an issue with wills that occurs sometimes, most of the time, when either a will does not have the specific testamentary intent listed in the will, and what can be done in regards to that. So, for example, one item that you would look at is extrinsic facts and other documents. Okay, and what this means is that even though you have a will, even though you have written on the will what you want, you are able, on certain circumstances, to use those facts outside of the will to essentially fill the holes, to essentially show what the intent of the testator was. So the first item that we would look at is called the doctrine of facts of independent significance. What is this? Well, basically, this is when drafting of a will dispose of property by reference to a particular act or event that has significance apart from its effect on the disposition made in the will. Okay? And so in this particular case, with the doctrine of facts of independent significance, it will not matter whether or not the act occurred before or after the testator's death. Okay, and so that in many other cases is a surefire loser if it occurred after. So in this case, the doctrine of facts of independent significance is actually used quite often to ascertain beneficiaries whose identity cannot be determined properly through the will itself. Okay, so I mean, obviously, the best thing to do would be to prepare a will where the beneficiaries are specifically listed. But let's say that, in the will it says it will, devise whatever to children or to heirs or to next of kin. Okay, I mean, let's go with next of kin. I mean, what exactly does that mean? Does that mean all of the kids? Does it mean the grandkids? Does it mean uncles, aunts, sisters, brothers, parents? And so it's ambiguous essentially what exactly it means. However, a will not be void or invalid for vagueness because the beneficiaries' identities can be ascertained from extrinsic facts of independent significance. Okay? And so through this doctrine of facts of independent significance, it is possible to determine who it is that's being referred to and what their names are, what their relation is, so that essentially the will can proceed forward, doesn't need to be determined to be invalid, and the property of which it says is to go to these people can properly be devised to them. So, what other extrinsic facts can you use? Well, there's another doctrine. It's called doctrine of incorporation by reference. Okay, and this basically states that a writing which is in existence at the time the will is executed, can be incorporated by reference into the will itself. And this will show or manifest the intent of the beneficiary to permit the identification of who it is that's being referred to. So basically, a testator may incorporate by reference into his or her own will made by another person. Okay, so the testator essentially incorporates instructions based upon a paper which is separate and apart from the will, but it essentially is incorporated by reference into the will. So, like, what are some examples? Well, a contract relating to the disposition of the testator's body parts or for medical research, contract providing arrangements for testator's funeral and burial, a deed to real property devised by will, buy-sell agreements, stock options, a letter to the beneficiary, uh, which contains suggestions for the distributions of certain property, property agreements entered into. It goes on with the different types that can be incorporated. Now that doesn't mean that there's going to be zero issues and so forth, but in regards to this, you can either have the doctrine of facts of independent significance or the doctrine of incorporation by reference. Those two doctrines are important when the will itself is ambiguous, it is not clear, and it is vague. And basically, by using these two doctrines, you could save a whole lot of probate time and be able to proceed forward accordingly in order to execute the wishes of the person who has died. Okay, if you like the video, click like and subscribe, and more on the coming videos. Thank you.